2026-01. And at this time, the city attorney has an opening statement.
As everyone knows, this is a quasi-judicial hearing that involves the notice of violation for the two parcels that Mr. Martin's company is owners of. And it came to my attention yesterday that there's been a due process issue that has arisen. And the due process issue that has arisen was that by statute, it's 160D 406C. And as far as any administrative materials that are to be disseminated to the board or any interested party to the hearing, what took place was that staff did disseminate documents to the board. I believe it was last Friday. And yesterday, it just came to my attention that no documents were sent to Mr. Martin's company attorney, and that in and of itself is a due process issue. So we got a procedural issue that was not followed with the standards of what we're here for tonight, and coupled with the due process issue. And so I talked to Mr. Martin's attorney earlier today, and what the two of us, and she's not present, and based on our conversation. So what our conversation consisted of was that Mr. Martin would come here today, and he's going to present whatever he wants to present in just a minute or two. And then after he presents what he wants to present, then what I was going to do is instruct the board as to what the board should do or could do moving forward. I wouldn't say should, I said just because it's not my place, but could do moving forward. So that's where we are right now. Before we get started, I know that anyone that is going to testify as a witness, not as an attorney, but as a witness, would need to be sworn. So.
Okay.
Thank you.
Violation of the due process and general statutes. If you could share, I didn't realize there was 6, 7 members of class 5. So I have 6 passed one out. Yeah. So as Mr. McLeod stated this morning, my attorney received a phone call from Mr. McLeod that there had been a due process violation, which is held under the North Carolina General Statute 160D 406. So she responded back to Mr. McLeod in this email, if you guys want to follow along with me, and it says, I agree with your position. This is a due process violation. Moreover, I maintain the due process issue cannot be cured. Even if the hearing date is postponed, regardless, the board received materials that my client did not receive and has possessed that information, she said weeks, but whether it's weeks or days or whatever, prior to the quasi-judicial hearing. The bail cannot be unwrung, and the statutory language in the statute states that is shall. So there is no opportunity to cure this violation. The only remedy is to dismiss all of these pending violations. If the pending violation is not immediately resolved, my client will pursue all available legal remedies. That's what she sent to Mr. McLeod this morning. So if you'll turn over to the second page, there, she prepared this statement for me, basically reiterating what I just read to you guys. But in there, the general statute is then listed, and it says administrative material. The administrator or staff to the board shall transmit to the board all applications, reports, and written material relevant to the matter being considered. Administrative materials may be distributed to the members of the board prior to the hearing. If at the same time they are distributed to the board, a copy is also provided to the appellant, which is me, or the applicant, or to the landowner, if that person is not the appellant or applicant. The administrative material shall become part of the hearing record. Last week, Ms. Bigelow submitted records, including a memo to the board members, but failed to provide those to me, the appellant. With the same materials in its entirety, this direct violation of statute is a due process and mandates dismissal of the violation. Also on the back, I provided to you guys, or she did, the definitions of in a general statute of you shall and you may. And so you shall is not an option. It is mandatory that it would have been given to me. Instead, it was never given to me or my legal counsel. And so even if you continue this hearing to the next hearing, the violations of general statutes have already been committed. You can't, in her words, unring the bell or undo what's been done. So the only way to unring the bell or undo what's been done would be to dismiss these at their face, if you guys choose to do so. If you don't choose to do so, then as per the discussion with my attorney, because we're not prepared because we didn't receive anything, she was instructed there was no point in her to come here tonight because the hearing could not proceed forward if at best a continuance would have to be granted. That's it.
Thank you.
A minute to read this.
Yes, sir.
So the option of the board tonight would be to either grant Mr. Martin's request for dismissals or continue the matter till, I would say, the next regularly scheduled meeting of the Board of Adjustment. So as far as, so it's your choice. As far as the due process violation, if the matter were continued, then of course the city would provide the board again, and of course Mr. Martin's attorney. So there have been incidences where the Board of Adjustment has continued matters dealing with issues of the due process issue, procedural, or ex parte communications. So there's a laundry list of reasons why you could continue. It's upon the board's motion. So your choice today would be either to grant Mr. Martin's request for dismissals of these two NOVs or to continue the matter. And I'm speaking not only for myself, but his attorney, as Mr. Martin alluded to. We talked this morning, and it was like, you know, if Mr. Martin's request is not granted, then she agreed to continuance. It's the only way to move forward instead of trying to have a hearing tonight without her being present.
Mr. McLeod, can I ask a question? And actually, it's directed to Drew. Can you confirm that you did not send a packet?
She would need to be sworn if she's
Sworn in. If you were sworn in, please.
So to your question, Mr. Thompson, I did not send it to his attorneys. I was unaware of the requirement to do so. It was an oversight on my part and on staff's part. We had numerous conversations with our legal team in regard to this, and it was one of those items that fell through the cracks that we did not discuss as being a requirement. Typically, with quasi-judicial procedures, it's been our internal policy that we don't send those out. It seems like per statute, we should be doing that for everything, not just appeals, but for special use permits and variances and other things. So I think that's a standing procedural fact that we have to acknowledge that we haven't always done this. It came to our attention during this process that we've been making that mistake, for lack of a better way of phrasing that. It wasn't intentional. We followed the internal procedure that we always follow for disseminating your packets and the information to you. We weren't aware of the requirement to send it. We're happy to share that information. To my knowledge, the only information that his attorneys were not privy to were the memo that you received and possibly those 2 pictures. I don't know if they were included in the notice of violation. But I do know that she had access to both the notice of violation documents that were sent both from March and May 6th. We've shared communications in regard to those. It was the memo that she did not receive, which was a narrative, more or less, document of what I intended to go over with you as inclusions into your packet.
Drew?
Question in that regard, if this is an oversight and in fact a internal procedural issue, is that something that you would anticipate is going to be corrected?
Yes, and we're going to have 2 methods of correcting that. First is for quasi-judicial procedures. You won't be receiving information in advance. We feel that that's probably the most effective way to limit any sort of ex parte communication regarding these issues, since that was an issue that was brought forward tonight. And additionally, any exclusions from parties who should receive those documents. Since you have to base your findings on the facts presented at the hearing, we'll just present everything to you at the hearing going forward. Second would be if a request is made for those documents to be shared, we would share them with you. And we would do that for all quasi-judicial procedures, whether that's a variance, a special use permit, or an appeal.
Thank you.
You're welcome.
Any other questions for Drew?
So if we do continue, we just gonna go over it again? Is that-
Before you start talking among each other, Mr. Martin wants to be heard.
Well, I believe that was a statement to me. Were you asking me a question?
Yeah, I just asked.
He's asking me a question.
Continuous, it's just gonna be the same thing over again?
Yes, if it were continued, you would have the information that you've already been provided, which is at its face just the memo and the 2 NOB documents. We do have the exhibits that staff have prepared to present to you. That is actually the bulk of the evidence. That was neither shared with you nor the appellate party. So we do have a plethora of evidence that staff has prepared to present. You were only given the memo as guidance on what was being heard tonight. And then the 2 NOB documents that are already public record, public knowledge, they were partial to the advertisement for this. So you only have that. There is a substantial amount of other evidence that staff had put together to be heard, but as City Attorney Mr. McLeod has stated, it's completely your choice if you decide that you are interested in hearing that information and tabling it, or if you'd like to dismiss it. Staff acknowledges their role in this process. Yeah?
Question, when you say dismissal, you mean dismissing it without prejudice to bring it back if it's decided to bring it back, to refile that?
I can't speak to that. That would be a question for the attorney. It's my understanding it would be a dismissal of the cases as they currently stand.
Without prejudice?
Not an acknowledgement necessarily that there wasn't a violation.
Okay.
Would you like to speak to the prejudice?
I'm not sure exactly what Mr. Martin's asking for, with or without prejudice, so I'll let him be the
I guess what I'm asking is if it's dismissed and it's done without prejudice, it can come back if it needs to come back. I'm just asking a question, just for my clarity.
If it's dismissed without prejudice, it could be brought back.
Okay. That was just for my clarity.
And, anybody else have a question for Ms. Bigelow?
Thank you.
Before the board starts discussing this among yourselves, Mr. Martin wants to be heard again.
So it was of my understanding, per Mr. McLeod speaking to my attorney, that this was brought to staff's attention, and they were instructed to provide my attorney with this information as of yesterday morning. And as of today, at this current time, and this morning when he reached out, my attorney had still never received the documentations. And also in reference to the statement of the three things that we can do here, it's of my understanding you can either continue this, there will be no hearing today, or if you choose to dismiss this based off of the due process errors, that would be the two, but no hearing would proceed forward today, which was why my attorney was instructed to not be here, because it would only be a continuance or a dismissal at its face. It's my understanding you guys can discuss anything y'all want to discuss amongst each other about what you do have, don't have, but whether she sent you guys 1 or 2 papers or 20 papers, we don't know. We never receive those, and typically, I think as Ms. Mills, you're aware, in court, the defendant is eligible to the discovery. I still don't even know what violations that I committed in terms, of it, because I just received a blanketed violation statement that I violated the statute. The statute, if you read it, doesn't tell me how, where, or where I violated it at, it just says I violated it. It's kind of like getting a speeding ticket and not telling how fast you went down the road, you just were speeding.
So, Mr. Martin's attorney and I discussed this morning, we talked a couple times today, and I told Mr. Martin's attorney that the city could send the documents to her by email today. And since we basically agreed that there would be no hearing tonight, if I recall, I can't remember verbatim, but I was like, well, then I'll just wait to send them, another. Since there's not going to be a hearing tonight, I'll just wait. So that's not on the city. That's an agreement that I had with his attorney as far as I'm concerned. I don't know how she would take it, but that's the agreement that I had. We can send it whenever. There's not going to be a hearing today, so we can send it tomorrow, next week, or next month. But we would intend, if it's continued, we would intend to send it right away. And as far as, the crux of this really is buffers and whatnot, and I know that that's splashed all over these documents. So, as far as being totally unaware of what we're here for tonight, as far as any potential violation, I would say that I would be surprised if there's just absolutely no idea on Mr. Martin's part of why we're here, but that's just me. So if there's nobody else to testify or be sworn, then it's totally up to the board. Can't recommend one way or the other. It's just you take the facts that we presented, both parties presented tonight, and y'all can make a decision. Okay?
Thank you.
Question. Can we, as a board, go back in this room and discuss this before we?
No, the discussions would need to be open.
Okay, all right, that's fine. I was just asking that.
This is my question.
Are you questioning the board or are you questioning?
The board.
Okay.
In February, at our meeting, we approved a resent amendment on clear cutting. And one of the things that talks about in it is an exemption, says commercial and industrial parcels may be cleared completely if they obtain development approval within 5 years from the date of the issuing of the clear cutting. Now, this is a commercial area. It's on Freeway Drive and right next to the drugstore.
There's been no evidence of a permit. I mean, we've presented no evidence, so, I mean, it would be evidence that's presented to the board. So, I mean, if you've got, it can't be hearsay, even,
This ain't hearsay. This is in our minutes from the February meeting.
Okay, well, as far as the approval of a permit, I don't know.
Well, I just,
I mean, if you're reading from your minutes, if they've been approved, I'm not stopping you from doing
right,
it.
I'm just saying that we approved that commercial didn't have to have a clear cutting permit if they get a site thing within 5 years. So that's just my question to the board,
There's the if, it's,
Point of clarification, we are at this point just deciding if we're going to dismiss or continue. I'm just asking for a point of clarification. That's what we're just doing now, right?
so, you're talking about how,
Yeah, that's all we're deciding is if we're going to continue or we're going to dismiss. That's just correct. Okay.
all right, so I'll do it both ways. If you wanted to grant Mr. Martin's request for a dismissal of the violations, someone would make a motion, and then second, and then it's by the majority of the board. So, if you, on the flip side, if you wanted to continue it, then you can continue, for any reason that you feel appropriate. I think that what was discussed was, you haven't heard any evidence. There is the admitted due process issue that I brought that to Mr. Martin's attorney. She may have known before. I just have an ethical obligation to alert her. So I alerted her this morning. And so there's that due process issue, which Mr. Martin has he's talked to you about. And then there's the issue of, we haven't heard any evidence. Do we need to hear any evidence? Are we good with what Mr. Martin said? And if you are, then you grant his request. If you feel like that you need or want to continue it for whatever reason you want to, it's got to be, you got to state a reason. You can't just have a motion to continue. So the motion to continue would be based on whatever you're continuing.
Yes. So we need to continue. We need to continue.
Indicate that we'd be able to bring this motion back, is that correct?
It's just continuing it to another day.
Speak in the microphone.
Means that we will continue it to another day.
Okay.
Yeah, it just means that we will continue to another day. It's just that we continue to another time.
And resolve the notification issue in the meantime.
Well, it's gonna be continued to another time.
Okay.
I guess the question though is Willie right? We can't unring that bell, i.e. we goofed, we got this ahead of time compared to them. Is it fair for his standing to,
We didn't receive the evidence, we only received the memo and the NOV.
we got more than
we received a bit though,
this.
That's your agenda.
we received the timeline from the city.
It lays out the city's argument.
But I think.
I feel like
I
we
think
haven't
without
heard the
hearing
evidence. Right. How can you make a
Tonight,
decision?
we cannot, we need to continue,
Yeah.
because we haven't heard any evidence that's been presented by either side.
Right.
And so,
And then make
if
a
we need
decision
it in
on
a
that.
motion, then I'll make a motion that we continue for 30 days.
And your reason
Is that we have not heard any evidence, no evidence has been presented at this time? Is the reason that I'm,
July 15th, that's our next meeting day.
okay.
Okay, July 15th is our next meeting day. Now, reason would be to hear the evidence.
Yes,
Okay.
that both sides will be able to present evidence at that time.
Are you making a motion, Mr.
Yes,
Chairman?
ma'am. I
Okay.
made the motion.
That's sufficient reason? Because it doesn't address the legal issue of,
before there's a second, y'all could have discussion.
Yeah, it doesn't address the fact that this didn't send.
that we violated
I
his
mean,
his due
that
process.
still stands, whether we got,
What's the concern? I mean, we've not heard the evidence. We acknowledge the fact that there was an error in our procedure. And the question at this point is, can we remedy that and go forward from there as if that were something, in all effect, has no impact on the whole case? Is that a reasonable statement? The question is whether or not there's been any harm done to this gentleman's rights and his request, his right to address the issues that were brought forth today, okay? Has anything been harmed in his operation as a result of this error on our part by way of miscommunication? Is there a reasonable statement, Mr. McLeod?
Well,
we have been given a pretty,
Hold on.
so it's what Mr. Martin is saying as far as you can't unring the bell. That's an opinion. It's not necessarily a fact. So there's been boards in the past that have continued matters to try to cure the due process issue. I'm not saying that's where y'all want to go. I'm not saying that that's proper for y'all to do. I'm just saying that's been done. And whether or not to that board it unrings a bell or not, that's the decision that y'all got to make. His lawyer says you can't unring the bell. I don't know. That's just a matter of fact for y'all to decide. And like I said, it's your decision. All I can say is some boards have tried to resurrect due process. Where they've gone, as I stand here, I can't tell you.
Let's close. We did
The only
close it.
thing that I would say is when someone's due process has been violated, it's violated. When someone's civil rights are violated, they're violated. So if you've already committed a crime, which I give to you guys, which is a statutory violation of a you shall present. It's obvious you guys have multiple documents up there that was presented to you. So that's what my attorney is saying. So whether you move forward to hear this later, it doesn't negate my rights to proceed forward legally with the due process violation and the civil rights violations. That's what she's saying. So you guys can do what you want to do. However, the violations have happened. The city was instructed yesterday to provide my attorney with these documents. We wouldn't be here. They still didn't provide them. My attorney would have been here. We would have been handling this. It wasn't until today that he discovered that she still had not received them. That's when he notified her, because they were notified yesterday to provide that evidence so that we could proceed on it. Then it still wasn't given, to my attorney. Is that correct or incorrect?
That's incorrect.
So you didn't tell.
Let me tell
I mean,
you.
let's, yeah.
So I was talking with Ms. Bigelow yesterday. We had a 3 o'clock conference with her. So I alerted her that Mr. Martin's attorney had not received the information, that we had a due process issue. So there was a lot of documents, and she was going to have to get those back together. And I told her, I said, any documents that you're going to present at the hearing, get them to her. So she said that she was going to work on it, and she said it'd probably be first thing in the morning, because by the time we got through talking, it was after 4 o'clock. And she had other things that she had to take care of, and make a long story short, I told her, I said, just, we'll touch base first thing in the morning. And so I did touch base. I came up here at 9 o'clock this morning, and Drew wasn't in yet. So I got with her over the phone later, mid-morning, and we talked about sending the documents, and I said, I've already talked to Mr. Martin's attorney. I said, you don't need to send them right now. I said, just wait, let's see what transpires tonight, and then we'll reevaluate. So if there's anyone that's at fault, it's not the city for that, it would be me, but I feel like I did that with his attorney's permission, because we discussed it. And the way that our discussion ended was, okay, this is his attorney talking to me. I'm not going to come, since there wouldn't be a hearing, but Mr. Martin is going to show up and make a motion to dismiss. And I said, okay. I said, I'll be there. And then I called her back. I was like, what if the board doesn't dismiss his request for dismissal and then refuses to continue it? Then you're in a pickle. So we both agreed that if the board did not accept Mr. Martin's argument and dismiss the NOVs, then by the mutual agreement of the attorneys, the matter would have to be continued. There's been no evidence presented at all. And as far as the due process issue, all I can say is that if it's continued to July 15th, and if these documents go out, I don't know, tomorrow, then his attorney's going to have a month. It doesn't mean that she's not going to come back in here and raise a due process issue. And that's going to be another decision that you're going to need to talk about. But that, whether or not you can unring the bell or not, I can't, that's up here. But there was a due process violation, and it's like Mr. Martin said, you can't erase that, but can you cure it? And you can't cure what's already taken place, but can you sort of resurrect it to put Mr. Martin's interest back on the same level that the city is? And that's your call, it's not mine. So again, not to belabor the point, so your decision tonight would be you grant his motion, that's what the board wants to do, or you continue it. And then the reason for continuing it, I would submit, first of all, his attorney's not here. That's the reason. His attorney and I both agreed. She was going, I'm not going to be there, so it'd have to be continued. So lack of his counsel being here, and then if you wanted to talk about no evidence or due process, whatever it is, but I think one of the main things is that his attorney and I both agreed that if his request isn't granted, it's got to be continued. So upon the consent of the attorneys would be a reason, if you're not going to grant his request. And you want
Okay. All right. Thank you at this time. All right.
So
Thank you. No, wait.
I would like to amend your motion. An amendment to your motion.
Okay.
Okay. I would like to move that we continue because the attorneys have mutually agreed to do so, and the defendant's attorney is not present. There are some due process issues, and these can be continued until July the 15th. That is my motion.
I second that motion.
You have heard, it's been moved and properly second. So at this time, if you're ready for the vote, all in favor?
We've
Not-
got to discuss.
Oh, discuss, I'm sorry. Go ahead.
Was there a second?
Yes, James Motley, second. Discussion?
You know, in theory, I would say that we should continue it, but, you know, just to make the argument, let's say Mr. Martin won the case tonight. Now we're holding him back a month from being able to do whatever he wants to with that property. And we're leaving this case in limbo. I know, but it was supposed to have been.
But if we're continuing it, okay.
It's only a clear
No, we got a motion on the floor.
violation. It's no crime.
Yeah, so I think, I won't say that the bail can't be unrun per se, but the due process is violated. And, you know, normally I've been pretty consistent with city's position on a lot of things, but this one is, I'm sorry, I just think that the due process is done and the damage is done.
I agree.
We're ready for the vote. We need to move on with the, end of discussion, we need to move on with the vote. All right, all in favor? Right hand? For continuing? Okay, opposers have the same right. Okay. All right, motion carried, and the hearing will be continued to July 15th. Okay. At this time, will someone move to adjourn this meeting?
So moved.
Okay. All right. Vote. All right. Meeting is adjourned. All right, thank you.